Today we're going to get geeky. We're going to break down in extreme detail and talk about how, even though it's a wonderfully powerful position and opinion by Judge Cormac Carney in the Reno May versus Bonta case, I'm going to talk about how we can make it theoretically even stronger going forward in the Ninth Circuit and beyond, and really talk about some of the theoretical and legal underpinnings of this most powerful decision by Judge Carney, knocking out almost all of California's quote-unquote sensitive places, which, as you know, is a euphemism for government-mandated gun-free zones. Stay tuned. We're going to get super geeky on this video in 1 moment. Hey folks, I'm Mark Smith, host of the Four Box Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and a nominee in 2 separate categories for the 2024 Gundy Awards. Let's see what happens in January. All right, folks, so major victory last week in a powerful decision, powerful opinion, which I'll put a link to down below, by a federal district court judge, Cormac Carney, a U.S. district court judge in the District of California, Central District of California. Powerful opinion by Judge Carney. He goes through in great detail and points out why there are simply no historical analog laws to justify the existence or to show the existence of a longstanding historical tradition of restricting guns or banning guns in quote-unquote sensitive places or government-mandated gun-free zones. They're one and the same under American law. Thus, all that long list of alleged sensitive places enacted by the California legislature and Gavin Newsom, the governor, were declared unconstitutional and could not be legally a basis for denying concealed carry holders in California the ability to carry guns in those particular places. There's no basis or no historical tradition of allowing bans in places like financial institutions or hospitals, medical centers, parks, zoos, and so on and so on. Major decision by Judge Carney, very well reasoned. But what I want to do in this video is to take the reasoning and rationale of Judge Carney in that decision of Reno May versus Bonta and get into some of the more historical, scholarly, geeky details that really are underpinning his decision and really show sort of some of the more theory of where he's going and where he can go in the future with future decisions in this context and where the Ninth Circuit Court of Appeals may take it. Okay, so to begin with, Judge Carney, let's talk about the historical period. Now, Judge Carney talked in great detail about how California could not come forth with historical analog laws to justify these sensitive places. And again, as you know, once the text of the Second Amendment is implicated, the right of the people to keep and bear arms shall not be infringed by a particular gun control law, by a particular modern-day gun control law, the burden shifts. At that point, the law is presumed unconstitutional, and the government is presumed to lose, and that gun control law is presumptively illegal and should be struck down. So the burden shifts to the government, and basically it goes like, okay, government, it looks like this is a violation of the Second Amendment. You bear the burden now to come forth with a long-standing historical tradition of long-standing well-established laws going back to America's founding to show that the founding fathers would have thought that this modern-day gun control law you passed would be upheld by the founding fathers in the 18th century when they enacted the Second Amendment in 1791, the founding era. Now, Judge Carney didn't get into this in great detail. He basically went ahead and analyzed step by step, bit by bit, the various proffered historical analog laws that the state of California set forth to justify these sensitive place laws. But Judge Carney could have taken it to the next level and cut a lot of those analogs off at the pass and said, look, even assuming these analog laws were somehow appropriate analogs, Judge Carney could have written, he says, the fact is, these are all in the wrong time period, because if you look at what Judge Carney did, he basically dismissed all these analogs one by one by one. Perfectly fine, nothing wrong with that, but he could have also said, the reality is the only analog laws that I even need to consider under Heller and Bruin are those at the time of the founding in 1791, because it's crystal clear the Supreme Court pressed and over and over and over again is that you understand a constitutional provision at the time it was enacted. Think of it this way. If you and I enter into a contract today and we write it down, in 100 years from now, people are going to try to understand what that contract means. They go back and try to understand what did the words that you and I wrote down in today's contract mean today, and what did you think about it today, and what did I think about it today? It doesn't matter what someone thinks about our contract that we enter into today, 100 years from now, because what guides is our intent, our use of the words, what those words meant, and what we intended the contract to accomplish. So too, the quote-unquote sort of social contract, if you will, of the Second Amendment. What did the Second Amendment mean in 1791 when it was enacted? That's the relevant time period. So if you want to show some sort of restriction or gun control law that would conceivably be acceptable under the text of the Second Amendment and the history of the Second Amendment, you have to go back to the people and the time it was enacted in 1791. It makes no sense to look at other time periods. So I think that Judge Carney could have done that and talked about that in his opinion here. He also could have cited, for example, one of my articles in the Harvard Journal of Law and Public Policy, where I laser focus on exactly this point, that if you look at Supreme Court precedent, not just in the context of the Second Amendment, but in all aspects of their application of the Bill of Rights, First Amendment, Fourth Amendment, and so on, they always laser focus on 1791 when the Bill of Rights was enacted, even when those things are applied to the states, because you cannot have one interpretation of the Second Amendment as it applied to the federal government and another interpretation of the same Second Amendment as it applies to the states. The Supreme Court has made clear you cannot have two separate understandings of the First Amendment, of the Fourth Amendment, of the Second Amendment, of the Eighth Amendment, one that applies to the federal government, another that applies to the states. You can't have it. They all have to be interpreted the same way, regardless of which government entity those are applied to restrict their behavior. And of course, we know from longstanding Supreme Court precedent that the Bill of Rights is interpreted at the time it was enacted in 1791. So Judge Carney could have laser focused and done a little bit more with that and made his opinion even stronger. And I suspect down the road he probably will get into this, because this was on a preliminary injunction basis. I'm sure that Judge Carney and his clerks were working really hard to get this out the door fast. But again, down the road, when he ultimately enters, I think, summary judgment in favor of the 2A plaintiffs here, he may want to feel the need, or may want to even buttress and strengthen his argument a little bit more with the point that a lot of the historical analog laws that the anti-gunners came forward with and California came forward with were totally outside of the 1791 time period and could just be dismissed as too late in time and not relevant. The second thing I think it's very important, Judge Carney did a pretty good job on the how and the why. And what I mean by that is this. For the sake of argument, let us assume, well, what happens, of course, is that when the text is satisfied, the burden shifts to the government to come forth with historical analog laws. What exactly are these historical analog laws? Well, every single historical analog law, in order for it to possibly be considered, the how of that law and the why of that law have to line up with the how of the modern day gun control law and the why of the modern day gun control law. Now, that's a little convoluted, but what am I really saying here? What is the Supreme Court saying when they say that a historical analog law from the 18th century has to be analogous to the how and the why of a modern day gun control law? What I mean by this is this, that to justify a modern day gun control law, let's say an AR-15 ban, the historical analog law on the books that's actually enforced, that was really a law at the time of our founding, first of all, it has to be a law, which means it has to be either a state constitution, it has to be a federal constitutional provision, it can be common law, which means case law, or a statute. It has to be actual law. It cannot be airy-fairy history or some narrative of some PhD historian from Harvard just saying, standing on the river of the history as it goes past us, this is what I think the Founding Fathers would have wanted. No, that's not what it is. The Supreme Court has made crystal clear in Bruin that actual laws on the books that could be enforced at the time of the founding are the first step. Those are the only historical analog laws that can be considered. Step one. Once again, you find an actual law, a gun control law, let's say you do, on the books at the time of the founding, the how and the why has to line up with the modern day gun control law. And what does that mean? Let's take a classic example of what the anti-gunners always like to talk about. They always like to talk about those handful of black powder storage laws in places like Boston that say that you could not store, massive amounts of black powder in your home. Now, the anti-gunners say that justifies, for example, a ban on the number of magazines that a number of rounds that you can have in a magazine and you carry your semi-automatic pistol, because they say that at the time of the founding, there were restrictions on black powder possession, and therefore they can restrict the amount of ammunition that you carry in your semi-automatic pistol in the 21st century. But here's the thing. Remember how I said the why and the how have to line up? Well, here's an example where the whys of the 18th century law does not line up with the why of the 21st century law, meaning the why the 18th century ban or restriction, I should say, on black powder storage, massive amounts of black powder storage in one's home in Boston, for example, the why of that was because they were trying to prevent fire. It had nothing to do with why modern-day gun control laws supposedly exist, which is to prevent crime, to prevent terrorism, to prevent the misuse of firearms. That is the why the anti-gunners claim that they want to restrict the number of magazines in a round, number of rounds in a magazine to 10 or less, because it's about crime control and public safety in that sense. But the why of the black powder rule of the 18th century was about preventing fires. So in that instance, the black powder rules do not justify the modern day restrictions on the number of rounds you can have in a magazine, because the whys of those laws are different. That would be a classic example of why the whys have to line up, and when they don't, then that law from the 18th century, in this case, black powder storage rules, do not justify, cannot be used to justify a modern day restriction on, let's say, the number of rounds in a magazine. Now let's talk about the other thing. The law not just has to have a why, but the law, historical analog law, also has to have the how. So the why has to line up and the how has to line up. Now what is the how? The how is how the law was enforced. So for example, let's take Bowie knives. So Bowie knives sort of come onto the scene in a robust way in the early 19th century. Now, here's an example. So there were some concern in certain jurisdictions about Bowie knives. That's true. Some concerns in some jurisdictions. But here's the key of the how. So how were Bowie knives restricted? How were they restricted in the early 19th century? They were restricted by virtue you had to carry them openly and you could not carry them concealed. In other words, they were not banned. So the concern about Bowie knives, how the concern about Bowie knives was addressed at the early part of the 19th century, assuming for the sake of argument this is the relevant time period for the sake of argument, the how was different than the modern gun control bans on, let's say, AR-15s. Because the Bowie knives, the restriction on Bowie knives was you could not carry them concealed, you had to carry them openly. So the how the law was enforced was not an outright ban on Bowie knives. It was a restriction on that you, again, could not carry them concealed, you had to carry them openly in certain jurisdictions. Now, if the anti-gunners want to use those Bowie knife regulations to justify a ban on AR-15s, they can't do it because the how the laws worked are entirely different. The how the law worked in the Bowie knives in the 19th century was, again, how you carried them open versus concealed, whereas the how the modern day gun control laws dealing with AR-15s are enforced is it's literally a ban on them. You cannot possess an AR-15 with a telescoping stock. You cannot possess an AR-15 with a protruding pistol brace or whatever you want to call it. You see, so the hows don't line up. So again, this is an example of how the whys and the hows have to line up, and this is why they often don't. So I think if you actually, Judge Carney does an excellent job of talking in great detail about how the how and the whys of the various analogs put forth by the state of California did not line up, and I think he can continue to do so. But I think in the next context of another opinion, or maybe the Ninth Circuit can kind of get a little bit more theoretical on how the hows and the whys work to really show that these laws that California comes forth with simply don't meet the how and the why test in like an infinite number of ways. Now, the next thing is, let's talk about what makes something a sensitive place. And this is something that I kind of kick myself because I've been thinking about doing this video for a few months. I haven't done it, and I'm going to do a very serious video about what constitutes a sensitive place and the different sort of theories that are out there, and really the best one based on the historical record. The bottom line is this. Judge Carney did an excellent job of pointing out that the sensitive places or government-mandated gun-free zones flagged by Bruin were really three. They're polling places, legislators, assembly chambers, and courthouses. Now, again, this is at the time of the founding. I don't want you to send me tweets or comments that say that today, the 21st century, when you go to a polling place, there's no armed security. That's not what we're talking about here. What we're talking about here is at the time of the founding, the Supreme Court has said that there's three sensitive places at the time of the founding of the 18th century: polling places, legislators, and courthouses. And what is the thing that is the unifying theme, the unifying fact in the 18th century? Not necessarily today, but in the 18th century. What makes the three of them sort of coherent as to why they'd be sensitive places. And what they all have in common 100% is that in each instance, the government stepped into the breach and they said, we, the government, will handle the armed security. We will have bailiffs with guns and arms in courthouses. We will have the sergeant at arms with guns in legislative assembly chambers. We will have sheriffs and their deputies armed to protect polling places. So that is the universal thing. It's the comprehensive security. And again, government cannot do what they're doing today, which is simply to wave a magic wand and to say zoos and public parks and schools and whatever, these are all gun-free zones, and just put up a sign. That is just not going to fly. The only way a government place can be a place can be gun-free is if the government provides TSA level comprehensive security, metal detectors, and armed guards. That's the only way it can possibly be a gun-free zone. And that is, I think, something that Judge Carney can do a little bit more work on in his next opinion when he does his final judgment in this case, and not just on a preliminary injunction. He can point out really the theory behind why these places are sensitive, according to the Supreme Court, is the fact that they provided armed security paid for by government at the time of the founding, and that is key. It's also consistent with the view that says that government has no duty to protect us from criminals unless, of course, they take us into custody. They basically bring us into their little confines and say, we will handle this like in the back of a police car. So again, if the government wants to say, we're going to take control over your body, we're going to bring you like into TSA, and we're going to protect you, and if something goes wrong, we're going to pay the bills, it's going to be on us. Well, again, that's kind of consistent with modern day theory that government generally has no duty to protect us unless, of course, basically they take us into custody. And on a related note, there's another aspect of a sensitive place that I think Judge Carney did a really good job on, and that is dealing with schools. And I want you to say this out loud, repeat this after me. At the time of our founding, schools were not gun-free zones. I repeat, at the time of our founding in 1791, schools were not gun-free zones. The only thing that occurred in some of the schools at the time of the founding was that students in some schools were prohibited from bringing guns to school. It had nothing whatsoever to do with the parents, the adults, the teachers, the maintenance workers, other people that had a reason to be on campus. It only restricted the rights of students to bring guns. That was mostly because at the time of the founding, the students were very young, even at universities. 15, 16 years of age was not unusual for them to be in university. They're very young. And the theory as to why students could be banned from having guns on campus, but nobody else could, is that the adults, the faculty, the administrators, the teachers stood in loco parentis to the students. So basically what makes the schools potentially have the legal authority to restrict the ability of students to have guns is that the faculty was functioning in the stead or in replace of the parents for these extremely young students. So I think, again, the reason why students could, and this is why this is so important. Listen carefully to this. Very important, okay? Because what the anti-gunners are trying to do, and I'm gonna nip it in the bud right here, right now. The anti-gunners like to say the reason why students were not allowed to have guns at the time of the founding on schools was because the students were viewed to be vulnerable individuals. There were populations of vulnerable individuals in schools. So the anti-gunners again say wherever there are vulnerable individuals, it allows them to ban guns. And then they can say, well, that means schools, and that means, children, and then, people that are sick, whatever. But that's not the case. What allowed them, the theory that allows students to be disarmed on campuses or in certain schools is, again, the in loco parentis relationship. It has nothing whatsoever to do that the students are vulnerable. And because of that in loco parentis authority distinction, it prevents that school restrictions on students from having guns from being abused by anti-gun judges and to use that analogy to ban guns in various other quote-unquote sensitive places. And I think Judge Carney in the future could talk about how this as a theoretical matter is about in loco parentis, parent to or adult to student relationships having nothing to do with the students being vulnerable or involving vulnerable individuals. That is not the coherent thread that ties all of those rules together involving students not allowed to have guns on certain schools at the time of the founding. So anyway, so there you have it, folks. A little bit of more theoretical discussion of the underpinning of Judge Carney's very powerful decision in Reno May versus Bonta. And we will certainly be covering the Reno May versus Bonta case a lot more in the future and tracking the ongoing excellent work of Judge Carney. I have a feeling that down the road when he does his final opinions on summary judgment and whatnot, you'll see all the powerful language from his first opinion on preliminary injunction, which was a preliminary injunction. And I think you can even do an even stronger, more powerful opinion with more theoretical concepts and showing the underpinnings of a lot of the Supreme Court precedent. It's not mission critical, but I think it might be helpful to take in the decisions in these sensitive places case to the next level, whether it be in Judge Carney's courtroom or in other courtrooms in California or at the Ninth Circuit itself. But only time will see. Only time will tell as to how this all plays out. And in the meantime, I hope you learned something here today at the Four Boxes Diner. I hope you follow me on X at Four Boxes Diner, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.